Hello, everyone. It is Adelola Dow, and I have with me Stephanie Hunnell and Rebecca Levin. Hi, ladies.
Hi.
Hi.
So we're coming to you live this time on my Facebook page for my law firm, which is the law offices of Adelola Dow. I am a matrimonial and family law attorney in the state of New York. I also practice a little bit in New Jersey, but that's Stephanie's territory. I'll kick it over to you, Stephanie, to introduce yourself.
Oh, thank you. I'm glad we're doing this on Thursdays. I really think it's a good platform. My name is Stephanie Hunnell. I have the Hunnell Law Group in Asbury Park, New Jersey, and I also practice in divorce and family law, and I have done that for about 16 years now. So I'm really excited to bring some new information to you guys every Thursday from New Jersey. Rebecca?
Yes, I'm Rebecca Levin. I am a partner with the Journer Law Group. We are based out of Philadelphia, Pennsylvania, and practice in Philadelphia and the surrounding area in Pennsylvania, as well as we go into South Jersey. My practice is family law. It is also assisted reproduction law, as well as a little bit of estate planning, and I have a law partner who does most of that work.
So since we left off with you, Rebecca, today our conversation is surrounding custody and parenting time and how COVID-19 is impacting that. Have you had any changes in your court being accessible for new applications since we were last live?
I would say that our courts are varying. In Philadelphia, the access is still the same as what it was when we had discussed child support. There's access for emergency custody filings as well as protection from abuse filings. It's very much in the discretion of the judge what constitutes an emergency. For example, different judges are taking different lines on whether not having contact with a child for an extended period of time constitutes an emergency if the child's not otherwise in danger. So we're seeing differing, more people are having experience as to what constitutes an emergency. And as long as the emergency declaration has been going on for longer, we're getting a better sense of what's an emergency, what's not. Is an emergency, not seeing your child for a week may not be an emergency, but not seeing your child for 2 months, could be considered an emergency. Other counties, not Philadelphia, are having increased access. We're seeing more guidance come from different courts in the counties as to their emergency procedures, accepting e-filings, letting us know, that they're operating in some limited capacities and moving towards increased operations over time. There's also some of our counties are putting out guidance, really wonderful guidance about custody best practices during COVID.
Okay. Stephanie, what about you? Have there been any changes with respect to access for New Jersey courts?
So we were pretty good. New Jersey jumped on pretty quickly, like I said last time, with getting some e-filing access. Within a matter of the first week and a half or so, we had email access to file any emergent applications. So we could email those in. We had a series of emails for each different county. Then they set up an electronic filing system called JEDS. So that's still operational. It's very rudimentary. So you're filing your paperwork. You're not really getting a confirmation, or if you're filing a new pleading, you're not really getting a docket number. But it is up and running, so you can still file your applications. The one relatively new thing since the last time we've spoken, I think, is that we're now doing domestic violence trials via Zoom, provided the parties consent. So in New Jersey, we were able to access, getting a temporary restraining order from the police department, but we weren't really having the final hearings for these restraining orders, and now we are. But the parties do have to have mutual consent in order for that to take place via Zoom.
Okay. So New York has, just as of Monday, implemented a new system called EDDS for filing motions only. So, and your case has to be currently active. So you have to have been assigned a judge. If you're in Supreme Court, which is where our divorce cases are done, you have to have been assigned a judge. If you are in family court, you can file the motion using EDDS. I will put the links into my site later on. I haven't done it yet, so you'll see it at some point before the end of the week. With respect to the New York State electronic filing system, there are some counties that are live. There are some counties that are not. Richmond County, which is Staten Island, is not live. We are being told by our judges that we have to get consent orders or stipulations of our adversaries in order to actually file electronically. We have to upload those stipulations to the informational lead for the county clerk's office, and then that person will make your case an e-filed case. So there's still a few hoops to get through. Certainly if you're doing that and you're doing Supreme Court cases, you're probably better off having an attorney do it and not doing it pro se. There is some difficulty if you don't have access to somebody who has the information to get your case live. So that's what's going on with New York. We did a allocution last week, which is when you testify as to the grounds for divorce and to whatever kind of agreement you've come to. In New York, we call it a stipulation of settlement. We did start doing those last week, and I got someone divorced this week using that. So it's not that you can't access the courts at all. It's just that the way you go about accessing New York courts is going to be a bit stymied, especially if you are pro se. So, Rebecca, you were talking about directives for custody. That's what we're going to talk about today. What kind of directives have you seen coming out of your courts?
Well, I actually printed it out, one of them, because I thought that Montgomery County, Pennsylvania, which is just outside of Philadelphia, really put out a fantastic directive in terms of how parents should proceed for common questions that courts are seeing come up during COVID. And so I can run through some of them, and maybe as we go on different talking points, if you guys have in your states guidance on some of these same points, please chime in. So our general guidance is all existing custody orders shall remain in effect, meaning that even though there are stay-at-home orders, a custody order takes precedent over that. An exchange of a child pursuant to a custody order is not violating any sort of stay-at-home order. So that's been made clear. It also, the courts have written, and again, I'm drawing from Montgomery County, that all parties subject to custody order should adhere to CDC recommended protocols for COVID-19 and remain in one's home and refrain from taking children to public places. That's also in the guidance. Parties should take all precautions necessary to keep children safe and healthy at all times, or an obvious one. Employment by one party as a first responder, and I think this one's important. Employment by one party as a first responder, healthcare worker, or other essential employee is not a valid reason alone to justify suspension of an existing custody order. What are you guys seeing in your states on that point?
Stephanie, you want to go ahead?
Sure. There was a case that was reported in the New York Times, I believe, where a father went in and on an emergent basis, without giving notice to the mother, swooped in and said she's an essential worker, healthcare worker, and so that's automatically a danger, and I get sole custody of my child. And that eventually was overturned, but that was happening. It's one of the only. Well, there might have been another case that I heard about that wasn't as publicized, but other than that, that was happening. So New Jersey also has no guidance on preventing that from happening. So who knows if that's happened in other counties and we're just not hearing about it. So yeah, New Jersey really doesn't have any guidance. I know the ABA put out some guidelines, nothing to the extent of what you're reading, Rebecca. It really is just like communication and those kind of things. And I have a link to the ABA guidance. It's like 7 what is it called? 7 guidelines for co-parenting during COVID-19. And in reality, it doesn't address, yours addresses the CDC compliance with those protocols, which I think is very important. It addressed what happens with first responders. This ABA guidance is not. It's very touchy-feely, talking about communicating and making sure you have a good relationship, and making sure you're making accommodations with each other, which are all great things, but it's not anything that's solid protocol where we can say, look, our courts are directing us to do something this way, which I think is a great plan to say this, at minimum, when you're going to other people's houses, follow the CDC protocol. I think that's at a bare minimum what we should be saying in our state, but so far we're not saying anything.
Yeah, it's interesting. I am very impressed with the fact that these counties in Pennsylvania are putting out these directives, because I'll tell you, New York is right up there with New Jersey and hasn't put out any sort of directive. Some of the southern states have. New York is kind of sort of do what you need to do until you need to go into court in order to have something else be done.
Yeah.
And so, but I am telling my clients, and this was a question that we actually had come onto my Facebook page by a gentleman named Andrew. So Andrew, we're answering your question, and I will put the time frame down that we're answering it in, so that if you're not watching, you can see this. Stephanie just answered you about New Jersey. With respect to New York, all we're being told is that custody and visitation orders are still in effect. I will tell you that there was a New York Bronx County case that came out not last week, the week before last. Judge Latia Martin suspended a gentleman's parenting time. Now, in this situation, the gentleman had not tested positive for COVID, but members of his household had tested positive for COVID. And so the parenting time was suspended, and he was allowed to do Skype, telephone, Facebook, that type of thing with the child. And I think that we can all understand that, because he couldn't actually guarantee that the child was not going to come into contact with the person or persons who were COVID positive in his household. But what I've been finding is that a lot of people just don't want their child to even drive with the non-custodial parent, or they don't want their child to be at the non-custodial parent's home if the non-custodial parent is working, not a non-essential worker. You can understand if the person is, non-essential and they're breaking CDC guidelines and also the guidelines that Governor Cuomo has put into effect. But if they're essential workers and they are simply just essential workers, I would say, okay, well, if you don't know that this person is going to be likely to have been exposed to COVID, or you don't have anything more, then you really shouldn't be withholding parenting time. But of course, don't bring your child to the supermarkets. Don't bring your child to Home Depot, things like that, which would just be irresponsible during this time. But a lot of us have essential workers in our families. My husband is an essential worker, and you're without more, if that person is following protocols, I don't see that as being a basis for withholding parenting time. And I don't think that New York is going to be issuing any orders that indicate that, just because you're an essential worker, you don't have time with your children during this point.
Yeah. On one of the points I wanted you mentioned on what happens if a parent or a person in that household becomes sick, in the guidance that, again, I'm looking at the Montgomery County, Pennsylvania guidance, so different counties might do different things, but I thought that the guidance that they put out was really helpful and also interesting on this. It says that in the event that a party or any person in their household becomes infected with a respiratory illness or is showing signs of being infected with COVID, that the party should report that to the other party. And then it also provides guidance for what should happen, and it actually depends on where the child is when the person becomes sick, which makes sense, although partially is counterintuitive. It says that if the party giving notice does not have custody at the time of the report, the physical custody rights of the reporting party should be suspended, and the child subject to the custody order should remain with the other party pending the resolution of the infected of the infection or illness. But if the reporting party has custody of the child at the time of the report, then physical custody of the non-reporting party should be suspended, and the subject child should remain with the reporting party until the infection has resolved. And so I think that might go sort of counter to a lot of parents' instinct. Okay, this parent has tested positive or is sick. Let me go get my child. I think what the court in this is suggesting to limit exposure to an additional household, additional people, that the child should stay in that household. So I think that's interesting and does make sense. It goes on to say that there should be contact to the extent possible through electronic communication, such as telephone, Skype, Zoom, FaceTime, and other appropriate ways. And that should a reporting party have custody of a child being unable to maintain custody due to a conflict between the need for in-person supervision of a young child and the reporting party's essential employment obligations because of the illness, the parties should extend the child in a timely manner. So it really does provide some significant guidance there that I think, even though it's one county that's provided their take, I think that, it makes sense. And I would imagine that other counties would take a similar stance.
So early on, I mean, I'm talking like the very beginning, even before we were closed down, I had one particular client that was in the middle of some dispute regarding some post-judgment dispute. Mm-hmm. And they really were not able to get along very well at all. But my client was starting to feel some symptoms, and they were able to communicate really well. And the child happened to be with my client at the time. So the child ended up staying 2 weeks with my client. The other party came and would go outside and spend some time distant from the child. And they really made those couple of weeks work. And I can tell you from their experience, I mean, it's not a lot, but it's from their experience, that really helped mend some of that relationship between the two co-parents, because they realized that they were able to work together for a resolution. And ultimately, they ended up settling their post-judgment application because they were able to communicate better. They trusted each other much more. And they realized that they're both looking out to make sure that their child was safe. And that was what they determined was best for them. So this guidance, I mean, it was spot on with what they did. One party was sick. That party said, okay, here, I'm reporting to you that I am feeling some symptoms, and I was around somebody who might have had COVID. And they really did work this up. So I think that's amazing. Yeah. I want to contact that guidance for myself so I can give that to some of my clients.
Sure.
Stephanie, can you explain for the viewers who don't know what post-judgment means?
Oh, post-judgment. So after you've been divorced and you already have your judgment of divorce, if there are any issues that arise as a result of equitable distribution, alimony, child support, or any other issue that was contained in your judgment of divorce or property settlement agreement, and you need to go to court after, that's called post-judgment. So these are issues that are already resolved in your judgment of divorce, but they need to be tweaked or enforced or modified in some way. So that's what a post-judgment application is.
Yeah, so I am dealing with a case right now that is pre-judgment, so before the judgment of divorce has been issued. And unfortunately, the parties have 2 children. That's not the unfortunate part. The unfortunate part is that the eldest child has become positive for COVID. And both parties are essential workers. One of the parties only has supervised parenting time right now, just because of relational issues between themselves and the child, the eldest child. But the custodial parent simply said, hey, by the way, child X is positive. Child X does not have any symptoms. Have a nice day. And so, the non-custodial parent is stuck there saying, well, okay, well, what's being done about this? And these people have joint custody. What's being done about this? Are we just sticking child X in child X's room? What is the protocol? And I'll tell you, this, the point of me talking about this is to highlight what Stephanie said. This is the time when people need to communicate, because in this particular case, the custodial parent is not being guided by the custodial parents, by their attorney, to say, hey, listen, don't worry about whether non-custodial parent is going to try to weaponize this information. Just be as transparent as you possibly can. And to be honest with you, if anybody watching this or watching this in the future is in the middle of a custody case and something happens with respect to that child, you don't want to hold diagnoses and things like that close to your vest, because that is actually something that you're obligated to do as as the person who's going to be championing to be the custodial parent. You need to facilitate the other party's access to the child. You need to facilitate the other party's knowledge as to the health and general welfare of that child, and do so without worrying whether that person's going to quote unquote try to weaponize, because quite frankly, your transparency will go a lot further than their efforts to weaponize it if the court can see that you're actually trying to facilitate the best interests of your child. So
yeah, I think that Stephanie's example was a really positive case of people coming together and using something, negative, such as one party experiencing an illness, to really figure out a good solution. Unfortunately, not every family will come to terms. I have a case right now where, pretty much the same scenario. One person was exposed to someone that was COVID positive, and that they kept the child, and my client agreed keep the child for 14 days. That's the best protocol. But after the 14 days, they still continue to withhold custody. And I think that some people might be using the lack of access that we have to the courts in some counties to basically take self-help, or say, well, what are you going to do about it? And unfortunately, people may take advantage. And while there may not be repercussions right at the moment, certainly it's going to be important for their overall custody case in the future to show that they're cooperating and they're not taking advantage of a public health crisis to keep custody of a child.
In my experience over the years, it actually ends up being worse for people that do that. Not COVID related at all, but whenever there's health issues and health concerns of a child, I've had any number of cases that the custodial parent will say, yes, I took the child to the emergency room last week. Everything is fine. You don't need to worry about it. And not giving any details and not giving any upfront information. The end result in some of those cases has been a modification of their parenting time, and at a very minimum, a cautioning to them from the court that what they're doing is contrary to the child's best interest and contrary to their custodial agreement, which is joint legal custody. So yeah, I mean, I think that doing that and not being transparent can actually backfire on a lot of parents. And I think that when we're done with this COVID, if that is happening and they finally get access to the courts, I think that's going to weigh against them, especially if it's in the pre-judgment stage prior to the divorce.
Yeah, I have to completely agree with you on that. I mean, this is not the time to decide that you're going to stoop and conquer, because that stoop that you take is going to cause you to be conquered if you're not careful. And listen, people have this notion about lawyers, and thankfully the three of us are not these folks who just try to wrap up cases and blow cases up. If you have a lawyer who's saying to you, listen, the right thing to do here is to disclose what's going on, you got one of those good egg lawyers, most likely, and you should probably listen. A lot of the times, I'm sure all of you ladies have heard people come in and say, oh, the lawyer, sided with my ex and they thought my ex was right on something. Well, that doesn't mean that the lawyer's turning against you. It means that they may be trying to enlighten you as to how your position is going to negatively impact you if you hold fast to it.
Yeah, I agree with that approach. I think that the best, family law attorneys really prepare their clients for what's most likely to happen in the possible scenarios. And while it might seem like they could potentially be, taking the other side or maybe playing devil's advocate is a better way to put it, it really is important that they're informing you of the most likely result if you go to court.
So, Stephanie, have you been dealing with any of these cases currently?
What you mean, parenting time cases?
Yeah, parenting time, where parenting time has been withheld, or on the opposite, where parenting time is going on, and your client says that it doesn't need to be because of some kind of potential danger.
Yeah, so the few cases so far over the last couple of months that I've had specifically related to parenting time have actually worked out really well, and I've been quite pleased with my client's ability to communicate and negotiate and resolve their cases. So that's a plus, and I think I'm seeing some positive results of COVID and people communicating better. There are a couple of cases, one in particular with supervised parenting time, where a father had supervised parenting time and mom just said, nope, the court's closed, I'm not doing anything. You're not going to see your child, and we're proposing to have Zoom, parenting time. She refused to even allow Zoom because there was no supervisor available. So the workaround for that was, well, some attorneys offered to be a supervisor, and that was not sufficient for mom. Mom wanted a therapist. So ultimately there was an agreement for a therapist. Of course, mom then canceled an appointment, and we're now into 7.5 weeks or so of social distancing with only one scheduled Zoom appointment, therapy Zoom appointment. So I was actually looking in, and I reached out to the courthouse in New Jersey to find out what their plan is for supervised parenting time, because their parenting time was supervised through the court. And they did confirm the supervised parenting program through the court system is not operational at the moment. You can't schedule any new appointments, and they're not taking any new intake. So if you do need supervised parenting time as a brand new litigant, you're not going to get it. There is a rumor that they're going to try to put a virtual parenting time program in place, but that's just a rumor. They don't have anything solid. There's no directives. And this is, this is out of Monmouth County. So I don't know what other counties are doing, but in Monmouth County, there's nothing in place for supervised parenting time. So that is one of the issues that we're having that's been a bit of a problem.
Yeah, I would say that, I would say that we're hearing something similar, from our courts in Philadelphia in particular. Right now, the court nursery where supervised visitation occurs for people who are ordered to have that visitation at the courthouse, that is suspended. And I would say that attorneys and practitioners are really having difficulty trying to figure out what are safe solutions depending on the context. Certainly, there could be a situation where Zoom or FaceTime certainly seems appropriate, but depending on what the issues are for supervision, there's been questions as to whether even that could be appropriate if there's not a neutral there to supervise. And so it really is a big challenge, especially, oftentimes there's supervised visitation that's building for reunification purposes or some other reason, and that there will be months of missed parenting time for supervised visits.
Yeah. Rebecca, it seems to me that just from a Zoom conferences, Zoom meetings, that at least that would act as a way. So if there was another party there supervising, even if mom was there supervising and just watching the visit, because they're not together. If the conversation became inappropriate, you can just shut the computer and end the Zoom call. But it's being, you can just record it. So that would be some evidence of whether or not the conversation was appropriate or inappropriate.
Yeah, certainly there are definitely ways to work around, and that seems like one way. I would also say that especially in Philadelphia, there are issues with access. in terms of not just for supervised, but in general, access to the courts. While supervised on Zoom or some other platform might work, in Philadelphia, many of our pro se litigants without attorneys, may not have the means to have the technology to even be able to have a Zoom call. We have clients who are paying us, and so most of our clients would not fall in that position. But I think that's something that our courts in Philadelphia have really struggled with, as our surrounding counties have opened up to more virtual platforms that often will require access to internet and computer and other technologies. For example, as we're moving forward, we're starting to hear that we might be able to have custody hearings with all exhibits exchanged in advance and provided to the other party through some sort of electronic means or by mail. But where people may not have the means to have a computer, have internet, have a printer, have a fax machine, that's where we're really seeing some equity issues in our courts.
Yeah.
And, I made a mistake. The person who left the question about directives was Adam. Sorry, Adam. Not Andrew, Adam. So, with respect to the supervision component, that's a very, it's a hard area to deal with normally, right? It's definitely more difficult when we're in the midst of COVID. I have a few cases in the office now where either my client's spouse is supposed to have supervised visitation, or my client is supposed to have supervised visitation. And what's happening is that the visits are going through via Zoom here in Richmond County, and they're getting done by not by ACS. ACS no longer does these kinds of, and ACS is Administration for Children's Services. They no longer do supervised visits on Staten Island, at least. And so the New York Center for Interpersonal Skills Development is doing these visits. And they're doing them via Zoom. It's not the same, if you're a non-custodial parent, and you're seeing your child on a screen. It's just not the same for the child or the parent. And so I think that as the non-custodial parent, it's extremely important that you take these sessions as, the be-all and end-all with respect to how you approach them. Don't miss one. If you're looking to have custody of your child, or you're looking to have extensive parenting time, don't just say, oh, it's only Zoom, it's not a big deal. Take your time, because you don't want that to be used against you later. If you are a non-custodial, if you are a custodial parent, do the same thing. Make sure that your child is available to interact with his or her non-custodial parent. That's a part of your job as you're facilitating the relationship between the parent and their the parent and the child. And again, like we said before, if you are looking to be a custodial parent, that obligation is on you.
Yeah.
Thinking outside of the box a little bit, I had a client that was having difficulty being allowed to connect with his children, like just even FaceTiming or text messaging. And he ended up buying his son a Xbox. I think it was an Xbox, one of a gaming system, for Christmas one year. And then they downloaded maybe Fortnite or something like that. So they were able to play with each other and communicate this way, because that was the only means. Like, mom wasn't interfering, son was playing a video game, and then dad would play a video game, and then they would be able to have some conversation. Now, there was kids, his other friends were playing as well, but that actually helped build, it was a tiny little block to build and repair a relationship where there was some alienation going on. So I think thinking outside of the box to continue those little things, they do make a difference. Even though they weren't even getting to really see each other, they were just like talking through their earbuds. It really did help. There's an app right now called House Party. I don't know if you guys have heard of it. It's an app on the phone, and you can talk to a number of friends, and you can just go on, and there's little games that you could play also. So like if you can do, with even mom there in the same stream, play, you know, like solitaire or whatever games that they have on there to help facilitate that little bit of a relationship. So it's not just staring into a screen and talking to your mom or dad during a supervised visit.
Right.
Yeah, that's a great suggestion.
Yeah, it
And
is.
I think the age of a child also really comes into play when using that type of technology. That, as you know, a parent of a 5-year-old, I know that, you know, half the time is spent running away from the phone, and so coming up with some creative solutions, and even especially if you're a parent who's trying to build time and is in a situation where your time's been suspended, really, you know, again, thinking outside the box, you know, record a story, do things like that to try to find creative ways to build a connection.
Yeah, that's a great idea. And I will say that with all of these ideas, just make sure that doing them doesn't violate any kind of orders that you have in place. Right? Because as we've said, all these orders are in place unless they have been terminated by the court or by agreement. But make sure that you going on to you know, play Fortnite on Xbox, or even the recordings, or sending FaceTime messages or whatever, is not going to violate something like an order of protection or a restraining order or something like that. Barring that, do whatever you can to make sure that you you know, that you keep in contact, both as the custodial parent and the non-custodial parent. How do we, what are, have any of you ladies encountered the custodial parent being the essential employee yet? And the non-custodial parent, and Stephanie, I think you just talked about that case that was published in the New York Times, where the mother was a doctor and the father went in on an ex parte, which means without notice to the other side, basis to terminate the mother's access to the child. Have you seen any of that in your practice areas?
Yep. I have not, but I'm also muting myself for a second because there's a truck passing by.
Well, I'll talk. I actually don't have that scenario either, but I think that it speaks to the general, you know, flexibility. If you have a primary custodian that's having to leave the house every day and go somewhere, you know, sort of going with something like the right of first refusal, it may make sense for the other parent to have more time at this time because of schedules and obligations and things like that. And, you know, hopefully that parents will be cooperative in returning to normal schedules as things go back to normal, and not sort of holding it over someone's head that they were essential worker and so they gave the other parent more custodial time. But that seems like the most appropriate solution if you have one parent who is available and one parent who's not.
Right. Can you explain that term, right of first refusal, for our viewers who don't understand that?
Yes, right of first refusal means that you offer custodial time to another parent before asking a third party. And so often when we're writing custody orders, we define what that is. I tend, in normal circumstances, not during COVID, to sort of draw a bright line, sometimes at overnights. If you're a custodial parent and that was to be your custody night and you're not available, you would offer time the overnight to the other parent before asking a third party. I think when you get into hours, like 3 hours, 6 hours, it gets a little bit more confusing. But I think in these circumstances, if someone's going into work for an 8-hour shift and potentially leaving a child with some other relative, it might be better to offer that time to the other parent first, especially with all the homeschooling activities that we're being asked to do at this time, you know, to really have the parents being the ones who are involved in driving that, if it's possible for one of the parents to do that. Yeah, homeschooling is a whole nother issue.
I mean, if there's a if there's a parent on the homeschooling topic, if there's a parent that is going to be home throughout the day, you know, potentially that child should be with that parent during the day to take care of all of the, it's a big undertaking, right, a day?
Yes, especially when your child is like mine and likes to socialize before doing any schoolwork. Yes, it's an undertaking.
I agree.
Yeah,
And
so having a parent that's going to be home to be able to do that consistently, as long as you can agree to modify your parenting schedule a little bit to accommodate that, I think that's important, especially if they're younger children, because I think they're probably more difficult to keep them focused on the task at hand.
Yeah, and I think that even if both parents are at home, but one parent is required, has a more demanding job and is required to do things where they're not going to be able to be as supportive of the child, being flexible in those situations, it may not be appropriate for every situation depending on what other issues are at play, but in, a situation where one parent does not have to report to a job and another parent's reporting remotely and might be distracted with other things that they need to attend to, it's again another reason to be flexible.
Yeah, I recently had to tackle this issue of what is a school day versus what's not a school day.
Mm-hmm.
And so if we have this case in our office where the non-custodial parent gets an extra amount of parenting time on a non-school Wednesday.
Mm-hmm.
So my client, who is a school teacher, and the other side is a school teacher too, by the way, said, "Hey, but I'm homeschooling Johnny. It's a school day. They're not off from school." And this was an argument that adversary and I had to have because Johnny's non-custodial parent showed up for the non-school day visitation every single Wednesday. In the middle of custodial parent teaching the child. And we had that battle back and forth about whether it was a school day if the child was learning at home as opposed to learning at school.
That's interesting. I think that's that's the difficulty and the beauty of family law is that everything is such a case specific decision, and we can't just give out these general rules that this is how it has to be, because there's things like that are so specific that you're going to argue about, and to another couple that may never ever be an issue because you wouldn't even think about it being a non-school day versus a school day. That's interesting. I could see both sides of that argument too, by the way.
I guess I really could. There was one side that I needed to prevail. So,
well, yeah.
Yeah. What are you guys seeing in terms of custody evaluations? One thing that we are seeing and hearing is that if you have a custody case coming up, whether it's in a county that has limited operations or is closed completely, my understanding is that the courts are generally telling people to proceed as if your case is still moving forward on its scheduled date unless you've been told otherwise. Again, Montgomery County has been very good at giving us specific directives, and they said that explicitly no case will be continued because parties had delays in their custody evaluation because of COVID. And so I think that our custody evaluators are now having to find interesting ways to do evaluations if they're charged with doing an evaluation in a county that's explicitly said or not explicitly said that your custody case is moving forward on this day, whether you are have completed your evaluation or not.
So New Jersey doesn't have any specific guidance regarding custody evaluations, but they did address, experts. So if an expert is precluded from issuing a report or taking a deposition as a result of COVID, then that timeline will be told or extended depending on the circumstances. But there's not anything specific as to custody experts, but we also are moving our cases along now. So the ESPs, which is an early settlement panel, those things are moving forward, and we're doing those by Zoom. So your case management order, which is the order that you receive when you go to these ESPs, is going to dictate what's going to happen after, like how your case is going to be guided. So if you say to the court, this expert isn't going to be able to have their report for another 2 months now, even though it was supposed to be due in, 30 days, then that's going to be what's guiding. I think the arguments are really just going to be between the attorneys to figure out what we're going to be able to do.
Mm-hmm.
Right. So New York doesn't have any guidance, but in the cases where I do have custody evaluations going on, the doctors are not seeing the parents, or when they have the interactive meetings, they're not seeing the parents and the children.
Mm-hmm.
So they are postponing those and doing their meetings with this, with the father or the mother via Zoom or via Skype. But the interactive meetings, they are postponing. And so therefore, since they can't have the interactive meetings, I don't see how they could possibly have their reports done. Thankfully, our courts with regards to custody trials are simply not going forward with the custody trial. So you have time.
Mm-hmm.
We have not been given any types of understanding as to when the courts will technically reopen to hear these custody hearings. I have a couple that are scheduled for this month, and we've just been getting notices that say, we'll let you know.
Mm-hmm.
We'll let you know what the next date is, and we'll let you know what the next date will be. My team members have been trying to get in touch. Specifically, family court is more difficult to get in touch with here in New York. And we've just been leaving messages for judges' chambers and have not been getting responses yet.
Yeah, I would say that's important to be creative. Again, it varies by county. In some counties, we're getting cancellation notices, not rescheduling notices. I think they've been waiting to see for when things open up. In Philadelphia, there have not been those notices going out. So in some cases, litigants are showing up for hearings that are not happening because the court is closed. In terms of, reaching out to chambers, I think even in a county where courts are closed, it is important to try to work those contacts. I know that there's been some success even reaching judges' chambers in Philadelphia where most operations are closed and asking questions like, is our pre-trial memo still due? Judge, are you willing to have a conference? That's very much been judge by judge as to whether you could get a response from chambers. In a county that hasn't given overall guidance. Some counties have, and they say both counsel are willing to agree to a conference, will conference the case, and have given some general direction. But other counties like Philadelphia, it's more case by case. But I would still encourage people to reach out and see what response might be gotten.
In cases where your clients may have, I don't know if anyone has this. I do. In cases where your clients may have gotten custody or parenting time decisions that they want to appeal, what are your appellate courts doing? Are they allowing the notices to be filed for appeal or not?
So in New Jersey, we have e-filing for appeals as well. So if you have an appeal, you can just e-file your appeal. And there's giving you some discretion on timelines for getting transcripts and those kinds of things. But it's a very interactive system, so you're still able to file your appeal. I don't know how that blends in with a directive that we received that says essentially we're treating, I think it was March 16th through May 6th, actually as of yesterday, so there probably is a new directive out today, as of May 6th, that said any of these dates are considered as if the court was closed, so like a court holiday. So certain filing deadlines are being told. So I don't know how that mashes up if you're going to be able to just file an appeal after all of this is over with and it's been, beyond the 45-day time limit.
Yeah, most of our courts, or actually have issued. Sorry, there's a little feedback on my computer. Most of the courts have issued guidance that all deadlines are sort of told in the same way that Stephanie was describing, and so that's for appeals as well. Because I think in some counties there's going to be some practical problems also obtaining what you need for an appeal and getting it docketed.
Right. Yeah. Our time frames have been told except today, the second department, New York is made out of 4 judicial departments. And so the second department, which covers Brooklyn, Staten Island, Queens, and Nassau and Suffolk counties, White Plains, that court has issued a directive saying, all right, we're back in business. Here are your new deadline dates. So if anybody has any kind of appeals or anything that are out there that need to be perfected, when I say perfected, that means that all of your documents have to be briefed, and you have to have your transcripts, etc. If you are the filer, you now have new deadlines to do that by, and I think the deadlines begin in the first week of July. So that's something that you're going to want to pay attention to if you are trying to appeal. What about the instances where you have custody agreements, where people have come up with parenting agreements that they want to have ratified by the court or accepted by the courts? Rebecca, do you all have an acknowledgement requirement? Does a notary have to sign your parenting agreements?
No, you can get things signed without a notary or attorney signature. And so we're going to that, where actually I drafted agreements and then removed my notary block because it's not required, especially where it's being filed by an attorney. And so that's one way that we've not gotten around. Pennsylvania issued a directive that for remote notarization for many things, but we're finding it's very difficult to find remote notaries, because while that's now allowed, there's a process to go through to get certified, and not that many notaries have been able to get approved through that process.
Oh, wow. Okay. Stephanie, with respect to New Jersey, do you need to have your parenting agreement notarized in order for it to be effective?
We do not, no. And I mean, I think traditionally we always have a notary block on it, and we notarize our client's signature. It's just as a matter of habit and form, but it's not required in order to be filed with the court. And they just relaxed the rules, but on account of COVID, they've relaxed the rules regarding original signatures. So we can now file these consent orders or consent agreement stipulations with the court with a copy signature or an electronic signature, and they'll be honored.
Right. So in New York, you also don't need and this is, I had a question from somebody, so that's why I'm asking this. You don't need to have your parenting agreement notarized in order to have it be effective in New York either. However, New York, much like New Jersey, has stated that you can have the agreement that you present to the court be a facsimile or an electronic signature. But you do need to get the original document to the court in due course. So whenever the non-essential documents start to become available to be filed, you do have to file the original document, okay, when that becomes available. On the topic of notarization, New York is fully allowing all documents to be notarized remotely. I know Stephanie and I were talking about
Lucky.
Yeah, this is where New York shines, Stephanie. You know.
Yeah. I was so excited for this legislation that was going to change my world, but it didn't at all. Family law is specifically excluded from remote notary, so there you go.
Yeah. So if you're in New York, you can have your stipulation of settlement signed, and we're doing that remotely. So for instance, in my office, my secretary will Zoom with you, see you sign it. She'll put her notary stamp on it. You can put it in the mail within 30 days, and we can therefore get you divorced. New Jersey is not so easy because family law matters are exempted.
Correct.
Rebecca, what about you?
So initially we got permission to allow remote notarization for certain documents mainly having to do with estate planning. And then later in April, it allowed notarization for additional things during the COVID period. So it says temporary authorizes for all Pennsylvania notaries for a period of 60 days during the COVID-19 emergency declaration. And so it requires audio visual. There needs to be a recording of the notary. But there is that allowance now that we can have remote notarization for many things.
So if you have a situation where your the custodial co-parent is not allowing you to see the child, and I'm saying you as, I'm just asking a question for Joe Schmo out there. Stephanie, what is your quick and dirty advice? And again, we're not your lawyers. We're just giving anecdotal advice.
Yes.
What would be the first thing that you would tell that non-custodial parent to do?
The quick and dirty of, just repeat that first part. I lost that first part.
If you're a co-parent and your custodial parent is not allowing you to see your child during this time, and there's no basis, you're not an essential worker, you haven't been exposed to COVID, nobody in your home is ill with COVID, what is your quick and dirty advice to that person as to what their next step is?
Look, my first advice is always going to be try to have a conversation and communicate and work it out amongst yourselves. And if there's a trusted third party that can intervene and help assist the two of you, to accomplish what you need to accomplish, I think that's my first go-to. But if that's not the case, and this just unreasonably withholding parenting time with no basis, then we have no choice but to file an application with the court. I don't think you should waste all that much time, especially because we don't know how long this is going to go on for. That's what we need to do to get you into court, because it's not going to be, as far as I understand it, an emergency unless it's just, I don't think it's going to be an emergency. I don't think a court in Monmouth, Ocean, Middlesex County, I don't know what they might do up north, but I don't think that they're going to consider withholding of parenting time for a small period of time, relatively small period of time, to be an emergent application. So I think you file and get into the courthouse as soon as you can.
Rebecca?
Yeah, I would echo Stephanie's advice in terms of first, trying to work it out to see if there is more information always before filing with the court. Reach out to the other attorney if there's an attorney on the other side, or the pro se litigant, to figure out, is there another side to the story? What is the concern? Why is custodial time being withheld? Is there a workaround? Are there safety concerns? Are there things that can be resolved? Assuming that the time is being withheld for no reason whatsoever. I think my thought on this and what I've sort of been thinking and hearing has changed a little bit as the emergency declaration has gotten longer, and we're now seeing what we thought might be 2 weeks of something going on for months. And so while I think each situation is different, and also it may depend in Pennsylvania on what county you're in, it very well could be the best option to file an application, because that's the only way to bring the matter to the attention of the court. That application might be rejected. It very well could be rejected, and it very well could be based on whatever judge is hearing it, whether interference with custodial time, not allowing a parent to see a child for an extended period of time, if that's an emergency. Because usually an emergency means that there is going to be imminent harm to the child, something that's going to cause the child harm. And if the child's safe, they're taken care of, they're healthy, they're not being exposed to anything dangerous, it very well under normal circumstances wouldn't be considered an emergency if there's not some risk to the child. But, especially in some counties that we know are going to be extremely backed up, Philadelphia being, the main county where our custody cases in Philadelphia, to see a judge, we have a tiered system in custody as well. And so when you file an application, it first goes to a custody master before going to a judge. So our master states, before the shutdown, we're about 2 months away, sometimes 3 months. Our dates in front of a judge from that master's hearing have tended to be about 10 months out from there. So you're waiting over a year to see a judge from your initial custody application if your case is going that far. And so we're expecting a flood of litigation once the court reopens, and filing something now might be your best means to the courthouse, because if you wait till things reopen, it could very well be months down the line before your contempt application is heard, which is usually what it is. Contempt being that someone's not following a custody order, and it very well could be moot by the time you get to court.
Right. Stephanie, I'll let you have the last word in here. It's an hour in. It goes by so fast.
This did go really fast today. I wasn't sure, and it did go really fast today. I actually have 2 points, if you don't mind. I wanted to make a correction because I said the tolling was through May 6th. It's actually through May 10th.
Okay.
So the tolling of the deadlines. And then with regard to appeals, there is a specific provision in the omnibus order that says with regard to appeals, the tolling provisions of the March 17th and March 27th orders and this order do not apply to appeals involving the termination of parental rights in particular. The tolling provisions do not apply to the calculation and enforcement of taking appeals and the prosecution and opposition of those appeals filed pursuant to the court rules. So I just wanted to.
Okay, thank you for the clarification. So I am so thankful that you ladies have again allowed me to talk with you and be in your general presence. You all are awesome. And I think that we have brought a good amount of information to folks who really needed it. We will be available to see any kind of comments that you might post later. And when we do our next live, we will try to address those questions first. All right.
Thank you again. I appreciate this.
For visiting with us. It's good to see you all.
You too. Take care.
Thanks for watching. And if you liked what you saw, please share it along. You can find links to my firm, Rebecca's firm, and Stephanie's firm in the host section of this event. Take care, everybody.
Take care.